Her, her interest is in intellectual property law, environmental law, human rights, and democracy and governance. Ladies and gentlemen, let's welcome the advocate of the High Court in Kenya, Mrs. Sharon Chahalewata. Mrs. Sharon?
Okay, I think Miss Sharon is still having problems with her sound. Yeah, but she's going to start now.
Okay, can you hear me?
Yes, we can. Yes, we can.
Hear you.
Oh, great.
Welcome. I think you are muted, Mrs. Sharon. You are muted on your side.
Oh, sorry, you can hear me now?
Yes, we can hear you.
Great, thank you. I'm here. So am I able to share my screen?
Yes, you can share your screen.
Share. Let me know if you can see it.
Yes, we can see your screen now, ma'am. Thank you.
Do you want me to go on or I may have missed the introduction?
Yeah, you can continue with your presentation, ma'am.
Okay.
Thank you.
Thank you so much for having me. I'm so glad to participate in this webinar today. And I'll just give a bit of pointers on copyright in the information sector. Yeah, so of course, for librarians or information professionals, they have to manage copyright issues. And sometimes they have to answer copyright questions and educate others about copyright or issues to do with digital licensing. So for this reason, you find that copyright is very important for a librarian or anybody that manages information to at least have a basic knowledge around it. Also, professional values of librarians, which include equity of access and inclusion, they rely on copyright law. Copyright law gives you the basis for people to be able to access in a legal manner. I think maybe at this point I may say that the goal of copyright is not to curtail access, but to balance the interest of the user as well as the interest of the rights holder, so that none of them is disadvantaged in any way. So of course, without copyright law, libraries would be unable to loan books, preserve content, and exercise fair use, which most of the time is provided for within the law. So we have, of course, library activities that are affected by copyright. There's purchase of books, and this includes even digital books. Then you have the right to lend. And the reason for this is that copyright gives the rights of, it's called distribution, to the owner of copyright. And so if a library is going to lend, you need to do that within the law. Then copyright regulates critical services that the library does, which is preservation of culture, access to resources, both for education and research, and then having access formats, e.g. for disability. In the Kenyan law, once Kenya signed the Marrakesh Treaty, we were able to amend our law and include exceptions for persons with visual impairment and print disabilities. So we already have made that provision in our law. We have signed the Marrakesh Treaty. I am not very sure about South Africa. When I was looking through online to look for the South African Act, I was seeing a very old act of 1978. So I wasn't very sure whether that is the current act that South Africa is using, but I'm sure the next speaker, when she speaks, she might speak to that. So copyright, I'm sure we know what it is. One of the things I wanted to pick out was that I found this very interesting provision in the Universal Declaration of Human Rights, Article 27. It says that everyone has a right to freely participate in the cultural life of their community, the arts, and share in scientific advancement. Of course, this includes research, yeah? And then subsection 2 says everyone has the right to protection of moral and material interests resulting from any scientific, literary, or artistic production of which he is the author. Of course, this includes books and it includes material that would be found within libraries. So I found that interesting that the Universal Declaration of Human Rights would recognize authorship and creative works and literary works as a right that everybody must have. And then, of course, the mother of copyright law worldwide is the Berne Convention. In Kenya, we also, when we did our new constitution 2020, it included articles that I've put there in my presentation, articles 11, 49, 40, 69, that talk about intellectual property, which includes copyright, that the government has an obligation to protect the intellectual property of the people of Kenya. So you can see in Kenya, we have given it prominence even in our constitution. In Kenya, the act that we use is Cap 130 of the laws of Kenya, which is the Copyright Act. And this act is actually a 2001 act. Initially, we had very old colonial laws that operated here. And then with copyright specifically, the act was redone in 2001. And we have had many amendments since. We had an amendment in 2019, in 2020, in 2022. And right now we are pushing a copyright amendment bill 2025. So you can see we have had to respond to a lot of things changing in the copyright landscape. So it has meant that we are doing amendments. For example, in 2019, part of the amendments was to provide for exceptions for visually impaired people and people with print disabilities. After we signed the Marrakesh Treaty, we made sure we had to include that in our domestic law. I think that's the same time that we provided liability for internet service providers, and we put a provision on a takedown notice so that whenever any material is infringed upon online, then the ISP has liability to pull down that material, and you, the rights holder, can give what we call a takedown notice. So some of those provisions were responding to the digital environment, and we have done that. But now we are doing actually a whole overhaul of the act, just to respond also a lot to the digital environment and other issues that have come up. In South Africa, I saw a 1978 act, and if you have a newer one, you'll forgive me on that. That's the one I found, which I found to be very interesting. I don't know how that act is able to respond to current situations, and probably that's a conversation we can have. So of course, copyright is the right that is given to creators over their works in literary, musical, dramatic, artistic. When you're talking about librarians and information professionals, mostly we're talking about literary works. Very rarely musical, but most of them we're talking about literary works. But now in Kenya, copyright also is covering software and computer programs. So then that means that any computer programs and software that you're using within libraries, you need to be aware that they are covered under copyright if it is in Kenya. Again, I don't know how the South African law is responding to that. So copyright protects expression of ideas and not the idea itself. And then of course, the term of copyright in Kenya is 50 years after the death of the author. If it's works that are unknown, the author is unknown, then it is usually 50 years after the date of publication. The rights that copyright is giving you, it gives the person, like the writer, the owner of the book or the publisher, is the right to reproduction. That within libraries would include activities like photocopying or scanning. Right now, scanning and storing stuff in the digital format is taken to be reproduction. Then, of course, there's adaptation, translation. Adaptation is making derivative works out of that work. You may find, e.g., in the world of books, you have book one, and someone comes and writes a sequel. That would be an adaptation. So you have to get permission for that. And then, of course, translation into different languages. Distribution. So what we do in libraries like lending is taken to be an act of distribution. So that is also a right that the copyright owner is being given. Communication to the public, making available to the public performance. This is especially with musical works. So these rights, the economic rights, reproduction, distribution, communication to the public, they can be transferred in terms of licensing them out or even selling them. But there's another right that is called a moral right that you may not, it is not transferable. This is the right that the author will retain for long. So the moral right is like the right to attribution. You have a right to be attributed to a work whenever it is used. The right to anonymity, you have a right to publish or write stuff anonymously if you do not want to be known as the author or use a pseudonym. And then, of course, the right to integrity, you have a right to complain whenever your work is being used in a manner that you would not like it used. So copyright issues and responsibilities that a librarian may find themselves or an information professional may find themselves dealing with includes the issue of photocopying and scanning articles. You need to know the limits within your law. Copying software or offering it for multiple users. Again, you would need to know whether you have permission to do that. And even in Kenya, a lot of the times, I work at Kenya Copyright Board. Of course, it's a copyright office, the government copyright office that is mandated to administer and enforce copyright. And so you find that sometimes we get a lot of complaints from people that their software is being misused or infringed upon. And you'll find a lot of the software that people use here is not genuine. So as a professional in the information sector, you would need to be very sure that the software you're using is genuine, and are you allowed to offer it for multiple users or not? Downloading or incorporating music into presentations and other course management systems. Again, you need to know whether the permissions are there or not. Negotiating permissions with others for the use of content. As a librarian, you're in a good position to negotiate for the permissions for what you want to use. Interpreting digital content licenses with third parties, you need to be able to do that. Applying fair use to a variety of situations, you need to know whether the use of the work, the material that you're using within your library or within your space, you can apply fair use. And fair use is not just open. Usually fair use has it has some guidelines. If you check in the Berne Convention, there's a 3-step test. For example, they say that it should not prejudice the rights of the owner of the work. So you need to know the bounds of fair use. Mostly you will find different laws are making provision for fair use and defining it. In the Kenyan law, it is there, but it's not defined. So there's exceptions and limitations in the Kenyan law, which says that you are allowed to use under fair use for criticism, for scientific research, for news reporting, for judicial proceedings. All this has been put under the fair use. So for example, if I was a librarian in Kenya or an information professional in Kenya and I want to apply fair use, I'd have to go to our act to check whether my use is fitting within the fair use provisions in the act. We also have a case that was determined last year that gave the three-step test made it a bit broad, and it gave almost a 6-step test to checking whether your use is fitting in fair use. So all these things come into play, the laws that are provided for, judicial decisions and precedents that you have in your law, in your country, I mean. Then, of course, you have to understand the exceptions set out in the copyright law. I used to work for a reprographic rights organization, and part of the places we went to talk to about copyright and wanting to license were, of course, institutions, universities, and most of the time, I spoke to librarians within universities, and they would say, we are allowed to copy up to 50%. And I would say, where did you get that? And they said, that's the standard. But when you check our law then said that you can copy up to 2 small passages of a work. And so I used to tell them, and some institutions even had IP policies that were not aligned to our copyright law. So that's a thing you would want to check, understand what exceptions are set within your law so that you're within the law. Also determining and researching when a work is in the public domain. Remember, when a work is in the public domain, you're allowed to use without permission. So you need to determine whether this work is in the public domain. Works come into the public domain when copyright expires, or works that the people are known, or in the Kenyan law, you're actually allowed to forfeit your copyright. So you need to determine whether the work that you're using is in the public domain, then you're in a safe space, you know you're able to use it. You need to teach others about complying with the copyright law. So that's why you need to also understand a bit of copyright law. And then you may have to answer a variety of questions around copyright. So you need to at least just know what it provides. I asked myself this question: if I was a librarian, what really would I need to know in this space to be always safe? One of the things you need to know is that copyright protects expressions of ideas and not ideas. So someone cannot tell you that I had this idea and someone stole it. It needs to have moved into a book, into an article, into paper somewhere, or online somewhere that it's protected. Then generally the rule is usually that the first owner of copyright is the creator. So if it was a book, the first owner of copyright is the author. The situation may change depending on the publishing agreement they sign. So you may find sometimes the publisher is the owner of copyright, but the law recognizes the first owner as the person who writes the work. That's at least in the Kenyan law. Different laws may be different. Then copyright protection is automatic. There's no need for formality for registration. Once you create the work, once somebody has published a book or put it out there online or whatever, and it's accessible to the public, then copyright is quite automatic. Then registration most of the time is voluntary, because again, I said protection is automatic, so you don't have to register. However, in the Kenyan law, we have an option to register your copyright, so you can get a copyright certificate. Different countries have different provisions in their law around registration. I'm not very sure about South Africa, but in Kenya, we are able to do registration, although it is not a must. Then only the copyright owner is being given the right to copy. So that means that when you want to make the use, you must make sure that either you have the permission or the license, or you can fit within the use that the law has agreed you can fit within. Then the duration of copyright, it is different in different places. In Kenya, it's 50 years after the death of the author. In the UK, I know it's 70. In the US, it is 70 years. You always need permission to copy protected material, either a license or permission, or you have an exception within your law. No permission for works in the public domain. Again, I've explained that the works that are in the public domain, you're able to use. Most laws, if not all, will have exceptions and limitations for copyright. So copyright will give you some instances where you don't need permission to use that, and you're able to fit within those exceptions and limitations. There's also fair dealing. It applies even to non-profit and profit organizations. As long as you can fit in the fair dealing provision, you're safe. There's usually exceptions for libraries and archives. In the Kenyan law, it is not very pronounced. It is not a lot, but we have provided for better exceptions and limitations for libraries and archives in the new bill that we are pushing. We did some public participation and we received comments even from IFLA, from IEFL, and other institutions. We received comments and we were able to incorporate them into our draft so that our law can respond better to the needs of libraries and archives. And then the other issue is that online works, images may be protected. I know that most people assume that whenever you find something online, especially images, they're not protected, but most of them are protected. But you also have an option to go to sites like Creative Commons, where you can find images or things that you can use. The ones that are under Creative Commons license, you're able to use such without an issue. You will find sometimes even those images say maybe the author unknown, but it's under Creative Commons license, or they will acknowledge who the author is, but it's still under Creative Commons license, so you're allowed to use that again. We have a lot of sites that have open access to a lot of material. So again, it is safer to use open access materials, because then you know you won't get in trouble with anyone and nobody's going to complain. Digitization of copyrighted material, sorry, that moved. On the issue of digitization of copyright material, once you are digitizing material within libraries, that increases the risk of infringement. So the library staff need to determine, one, that the exceptions and limitations of the Copyright Act are allowing them to do a certain act. Two, if there are any permissions that are required in order to digitize the items, then they need to digitize to get the permissions. I recently had a meeting with the Kenya National Library Service here, and they are also working on digitization, and they just wanted to know, what does the copyright law allow us to do? Do we need permissions? And are we able to get those permissions, and how do we get those permissions? And we were able to have a good conversation, and I pointed them to the right direction. And they had very good questions. What if you can't find the owner? What if the person died? What if, yeah? And we were able to answer the what ifs, but it is good to know that if there are any permissions required, then I need to get the permission so that you don't get in trouble. And your library staff also needs to know how to make copyright determinations and manage any risks that would be involved in it. Oh, when I was talking about exceptions and limitations, there are certain exceptions and limitations that your law would offer that may be provided for by the law. Some of them could be around preservation of unpublished works. Some laws, like in the US, it allows you to do preservation of such works. It allows librarians to engage in preservation to make a limited number of copies on unpublished works, yeah? That's the law in the US. Then you have preservation of published works. This one is usually a bit more restrictive, but again, some laws like the law in the US, it's called the Digital Millennium Copyright Act. It allows for preservation of published works to some extent. There's some restrictions on it. And then they've also have a provision in their law about interlibrary loan. So their law has provided that it can allow you to make copies to send to other libraries. So such provisions can be within your law. And if they're within your law, then you would really need to understand them and know how to fit with them so that you're not caught up in the on the wrong side of the law. But I think my emphasis today would be the major goal of intellectual property and protection is that you want to encourage the creativity to reward the person who has created the work, but you don't want to curtail access. Because if I create the work and it's not being used, then it doesn't make sense. If I write the books and nobody is using them, it will not make sense. So I want to write the books, I want to be acknowledged, I want to receive some monetary compensation, but at the same time, I need the other person to use, I need the user to use the work for that to happen. So the goal of copyright laws usually is to create a balance between the user and the rights holder so that the user can access legally, the rights holder will be encouraged to create even more and also receive some reward from their investment. I think those are just some of the few thoughts I wanted to share. Maybe if there are other questions or whatever, we can deal with them as the webinar goes on.
Okay, thank you so much, Mrs. Sharon. Let's give Mrs. Sharon a round of applause. We are going to take questions after the second speaker. So we are going to have a session specifically for question and answering. So now we're moving to the second presentation. So if you have questions, please note them down or please write them in the chat box so that we can present them in our next item after the second speaker. So thank you so much, Mrs. Sharon, for such a well-rounded presentation. We really appreciate it. And so we're moving to the second speaker. So the second speaker is currently working as a copyright librarian based at the University of Free State. She's a recently qualified professional and a role model in the library and information services. Her work extends beyond the university setting. She has a passion for library and outreach. So this led to the founding of school libraries and reading clubs in her local primary schools. And with a background in community radio, she brings a dynamic communication skills to her professional work as well as public engagement. She's also a contributor of the Library and Information Services podcast, which its focus is on exploring the developments and the conversation in librarianship. So all this led to her being awarded the 2024 Emerging Librarian of the Year, which is sponsored by the Nevada LMS. So ladies and gentlemen, let's welcome on board Ms. Xolelwa Qorile. Thank you, Xolelwa.
Good morning, ladies and gentlemen. As Mr. Simon has said, my name is Xolelwa Qorile, and as he has also said that I'm involved with Nevada, and this morning I'm wearing a different hat as a copyright librarian at the University of the Free State. So he also mentioned that I have a background in radio, so you will please excuse me just in case my presenting comes while I'm presenting, the radio presenting while I'm presenting. And thank you very much to Ms. Sharon for that background of, I think we needed like a law aspect in terms of copyright for librarians. So I'm coming in as a copyright librarian at the University of the Free State. And I think it's really important that we know as librarians what matters that we need to address. And that is because we're dealing with the material that is protected. And so in terms of giving our services, I think it is very important that we understand. So why copyright matters in the libraries? And of course, as I've said, that libraries are key access points for information. So we offer books, journals, films, and digital content to our users, and therefore copyright matters. So, but access doesn't really mean that it is free. Just because we are owning this material does not mean that we have the rights to be distributing it, however. So copyright ensures that creators are protected while also allowing for fair and legal sharing of knowledge. And it's also important that we understand that it helps us digitize responsibly. I think Sharon was speaking about digitization projects. So the way that we are doing it it helps us to do it responsibly, to lend legally, and to promote access without infringing the rights. And what role do we as librarians play? We can be circulations librarian, interlibrary loans librarian, digital scholarship, whatever librarian, whatever specialty that you are in when it comes to libraries. And this is because librarians aren't just content managers. We are copyright educators and gatekeepers. So we need to know the information when it comes to copyright and how to handle the copyrighted material. And therefore, it's also our duty that we teach our users what we know. So we also help users understand what's legal, what needs permission, and what's openly available. I think sometimes you get users who wants to make a copy of the book and they want to make the whole book. We need to know, what does the law say about that? Or sometimes they take just an image either from Pinterest or from Google and they think that they can use that image. And so we need to also know, what does it say, what needs permission and what is available out there. And Sharon also spoke about getting or using Creative Commons, some of these resources that we can use, that we can make sure that we're not infringing on copyright, OERs, which is open education resources, public domain, so that we are respecting legal boundaries when it comes to the copyright. So this is the current law that is speaking to copyright. And of course, the South African copyright law is governed by the Copyright Act of 1978. It is an old law, as you have said, but it's seeking amendment, and I'll just speak to it. So this law, it protects the original work, such as literature, music, film, and software, granting creators economic and moral rights for a set duration. And of course, I think also here in South Africa, it is 50 years after the death of the creator. And there are limited exceptions that exist under fair dealing for purposes like research and education or news reporting. So as I said, that there is an amendment bill of the Copyright Amendment Bill, and it seeks to update the South Africa's outdated 1978 Copyright Act. So this is to align with how we have moved in terms of, like, you know, the digital realities and the international treaties that are out there. So just to touch a little bit on what that bill, so another, what it seeks is to expand the user's rights. So to introduce a broader exception for education, libraries and archives, and people with disability, so that they can have accessible formats. Another thing that it seeks to replace fair use with fair dealing doctrine that is more aligned with the international laws. And it also seeks for creators' protection. Those are some of the things that it seeks. And the bill hasn't really been passed. I mean, the bill has been passed, but it is waiting for the president to sign it at the moment. So when we are talking to our users, or to when we're talking about the copyright, so these are the things that I normally train about when we say the do's and the don'ts. Just the basic things that we need to know is that when we are copying a material, it has to be really a small portion. So generally, we would say 10% or less for the work. And we always cite the sources that we are using to follow the agreed usage term if we have gotten permission. So however the agreement license says, we need to follow that to clearly also indicate the changes made to the original work. And of course, as I said, to always ask permission when needed, and to train staff or users on the copyright best practices. So at the moment, with the infringement and how the law wants to protect, is that if you infringe on copyright, you know, there's consequences, and we need to also understand as librarian that you can get from anything of 3,000 or 3 years imprisonment, or to 10,000 to 5 years imprisonment. So we need to be aware of this. And also there's disciplinary action, especially in the academic context, if there's any plagiarism that is involved. So libraries must model best practices to help avoid these consequences. So in this part, I'm just going to be speaking on how we at the University of the Free State deal with the copyright. So we do not allow any full copies on Blackboard without permission. So how we normally do it is we ask the lecturers or the academics to use link instead of uploading the content. If they are going to be uploading any content, we ask that can we then ask permission or rather first, and then once the permission is granted, then we then issue out a letter so that they can use the material that they want to use. And another thing is we've got short loan section in the library for textbooks, so the students can use those textbooks or prescribed material. So we work with Dauro. We're hoping that they will be part of the webinar today, just also to explain the work that they do there. So we work with them. Dauro is a South African main copyright licensing agency. So we rely on them to manage the licensing and the permission for reproduction of copyright works, especially for education. So this relationship helps us to be compliant while offering content to our users that they need. So at the University of Free State, we work with Nevada. It is our internal copyright management platform. So Nevada is the one that is actually providing that platform. So it manages all the copyright application workflows. So the lecturers or the academics are able to make the application using Nevada. So the selector will send through the request to myself at the Copyright Office, and we then connect it direct. So we then send the quotation that we have received and make sure that everything is in order. Then we process it using Nevada. It goes then to Dauro, and then Dauro will then send us a quotation. So the license that we currently have is transactional. So it means that for whatever we use, whatever content that we are using, we have to pay for. So just a reflection on the work that we do as librarians. I think the question is, how can we promote copyright conscience without limiting access of information to our users? And I hope that this morning I just shared enough on copyright. I will take any questions if there are any questions. And thank you very much, Chair.
Thank you so much, Kolelwa. Thank you so much. I can see at the University of Free State, you guys are doing well. So let's give Kolelwa a beautiful round of applause. So we are now moving into the item of question and answer session. So I think we are going to start with those who want to ask their questions, and then after that we move to the chat box, and then that's where we're going to read all your questions that are posted there. I can see Mrs. Sharon is already answering some of the questions that are directly to her. So can I have at least two people who want to ask questions? So you just raise up your hand and then you tell me you are asking, the question is directly meant for who, then we tackle that question. Okay, in the meantime, let me start. My question is directed to Mrs. Sharon. So I wanted to check with you. So in Kenya, do you have any statutory enforcement agency? Do you have one? And if so, is it established by the constitution or the legislation? That's my question.
You. Yeah. We had a CMO, reprographic rights organization like DALRO, but it died. So we don't have a CMO right now that is doing collection or licensing for literary works. But we have an anti-counterfeit authority that does enforcement. Part of the counterfeited material they find in the course of enforcement include pirated books. So they're able to do enforcement for that. But also the Kenya Copyright Board, where I work, has a mandate for enforcement. So usually publishers, for example, would come to us to make a report. We have a team of enforcement officers that are seconded to us from the National Police Service. So we have policemen that work with us. Our act, the Copyright Act, has empowered them to enter into premises, inspect infringing material, seize the material, make arrests, and the matter goes to court. Our legal staff, including myself, were actually doing copyright prosecution until 2020. There's an institution, the Office of the Department of the Public Prosecutor, that does prosecution. So it was taken back to them, but we were actually also doing copyright prosecution ourselves. So those are the mechanisms that we use for enforcement here.
Oh, thank you. Thank you so much. Thank you so much, ma'am. Anyone else?
I see Zama has a question.
In the chat box.
Her hand is raised. I think you can speak, Zama. I think. Yeah.
Oh, okay. Thank you, Colonel.
Good morning. Can you guys hear me?
Yes, we can hear you, Zama.
Okay, thank you so much to our speakers for the insightful information. I just have two questions, and either the speakers can choose which ones they want to answer. It's directed to both of them. So I just want to know, in terms of, let's say I've got a researcher that is probably outside of the country and requests me to make a copy of a chapter for them and send it to them via email or some sort of platform. Am I allowed to do that, or what are the restrictions based on that? Does that fall under fair use, or how can we tackle that as a library? And
Okay.
then okay, I'll ask my second question after you answer. Thank you.
Oh, okay. So I think Sharon spoke about the interlibrary loan. So how we deal with it at the University of Free State is that then we direct that to the interlibrary loans and ask the user or the researcher to request that material, or be the interlibrary loans that is facilitating the request.
Is this also for material that you guys have access to within the library? So
Yes.
if the book is available in the library, but the student or researcher is just away for that present moment and cannot come in to use the book themselves.
Okay, maybe I'll let Ms. Sharon, I think, yeah, okay, I'll let Ms. Sharon answer that. But I think for us then, if it is one, because if the student was here on campus, that is the amount that we will allow them to use within the library. Like, for instance, if they are making the copies for themselves. But maybe I'll just allow Ms. Sharon to answer that further.
You are muted, Ms. Sharon.
Sorry, I'm saying for us, you need to find out the portions that your law allows you to copy within that portion, and what provisions your law makes for interlibrary loans. So this has to be within the parameters of your law. The only disadvantage, Zama, is that I am not very sure about the provisions of the copyright law in South Africa. But in Kenya, it provides that you can copy up to 2 passages. So a whole chapter would really be going out of the law. We also do not have the provision for interlibrary loan within our act now, but we have provided for that in the amendments. So whenever you're doing an action, you need to make sure that you are aware of the provisions of what is in the South African Copyright Act. But definitely an action of scanning and sending material would be taken to be distribution and the reproduction.
Okay, thank you so much. And then my second question is, I usually have requests whereby researchers want to use figures or images that they find on Google. So then my struggle is, how do I now start tracing if that image or figure is under copyright and who the copyright actually the owner is? Where do I start tracking? Is there a platform that I can look at that can make my life easier in terms of getting the permission? Thank you.
Usually, this is my advice usually to people, that rule of thumb, assume that anything that is online is copyright protected. So that's the rule of thumb. Assume that whatever is online, it falls under copyright protection, unless you can establish it is in the public domain. So if you're assuming it's copyright protected, what you need to be finding out is that which site is this I'm getting this stuff from. We have sites online that you can get free pictures, but they're not really free because they are already paid for. The license, the Creative Commons license is already in place. You have Getty Images, I think Shutterstock. You can find the images there to use, but they would have a watermark behind saying Shutterstock or Getty Images. Those I know are safe to use because they're usually under a CC license. Or if you are sure that the site you're on is in the realm of open access, then you're okay. If you're not sure, do not use it. If you're not sure, I tell people do not use it until you're able to establish that it's either in the public domain, it's either on open access, or it's either under Creative Commons license. And with photos also, you could take your own photos. It's not hard to do. Now you have a smartphone. If you want a certain photo, you could take. One of the photos I used in my presentation was my photo when we visited Cape Town, University of Cape Town, and we were in the library. And I took a photo holding a book. So that's a personal photo that I can use in my presentations because I don't need to ask for permission for that. So you could ask them either to take their own photos or buy. Their sites you can actually buy photos from. So you can use Creative Commons licensed photos. You can use open access. You can get them on the sites that are free. Getty Images, it's a good place to get. Shutterstock is a good place to find. Does that answer your question, Zama?
Yes, it does answer my question. Thank you so much.
Thank you.
Thank you so much for your questions, Zama, and thank you for the answers, Mrs. Sharon and Xolelwa. Do we have any other question? Before I move to the chat box, do you have any hand? Okay. So in the absence of hands, I can see, Mrs. Sharon, you have been answering them in the chat box. Let me check.
Oh yeah, somebody was asking whether there is an international source of truth for copyright Q&A. The World Intellectual Property Organization site is a good place to find a lot of information on. Yeah, I see somebody here saying that the South African law allows you to copy 10% of the content. So that means you have to calculate what 10% is. If you have 100 pages, what is 10% of that? I know sometimes internationally they say 15%. So if you're allowed to do that, you would have to calculate the percentages depending on the work that you're dealing with. Somebody was asking about the South African copyright law, whether it addresses ownership and infringement. I think that was in, okay, I don't know how to pronounce her name, the other presenter. The one with the
It's Xolelwa.
Xolelwa.
Yes.
Yeah, I thought I saw that in your presentation on ownership and infringement.
Okay, so I didn't get the question. What was the question?
Someone was asking, does the South African Copyright Act address ownership and infringement issues or issues related to AI-generated content? Seeing that the South African law is a 1978 Act and AI-generated issues are very new, I doubt that that provision would be in the Act. In Kenya, our Ministry of ICT has just developed AI policy, actually. They have just developed an AI policy and strategy, but we don't have a law here that makes provision for AI. The conversations internationally around AI and copyright have been that with copyright, it is attributed to a person. The issues of ownership are attributed to a person. So with AI-generated works, are you able to attribute ownership to a machine? But then the conversation moves on and says the machine still needs a person to feed information for it to generate whatever. So then the debate has been, so are you going to give the copyright to the person feeding the information into the machine? Those are international conversations at WIPO around AI and even local. We have had lots of conversations around AI. One of the things I picked one day in an AI conference was from a script writer who said that he uses AI to assist him to write his scripts. And what it is doing for him, it's just halving the amount of time he uses in creating a script. So AI is just assisting him. But at the end of the day, he still has to come up with a storyline and to write the script himself. He will only feed the information into the whatever system he's using so that it's able to assist him to draft, but generally he still has to come up with a storyline and to write the script. So for us here, we only have an AI policy and strategy developed by the Ministry of ICT, but we are yet to have any provisions in our law speaking to ownership and infringement issues around AI-generated content. The other thing with infringement around such content, for Kenya, if I'm dealing with an infringement matter, mostly I need a complainant. The complainant is the owner. So if I cannot contribute and I cannot attribute an AI-generated work to an owner, then I will not have a complainant. And if I go to court with such a matter of infringement, then without the complainant, it's going to be very hard to push that prosecution through. I hope that helps you a bit, whoever was asking about that.
Thank you so much for providing us with those answers. But I think you touched on the South African copyright law as being old, but I think somewhere last year they passed the amendment bill in 2024. So at the moment, that amendment bill has been referred to the Constitutional Court. Last time I checked, so I'm not sure if it's back or something. But last time I checked, it was referred to the Constitutional Court.
I was in South Africa in January for a conference, and what I understood was that that bill has not yet passed. The South African copyright bill, it hasn't passed yet.
Yeah,
so
it's
that
waiting
means that
for the president.
Yes. So that means that as long as it hasn't passed, you're still operating under the old law, the current law as it is. Yeah. So that question was also talking about content on social media platforms like TikTok and yeah. In Kenya, we don't have a law per se regulating those platforms because those platforms are not Kenyan, most of them, of course. YouTube, TikTok, they're not Kenyan platforms and you're not really able to regulate them as such. But usually my advice to people is that whenever you're on those platforms, they have their own copyright policies and even ways of reporting copyright infringements. For example, YouTube, if I feel my work is being infringed, I can issue a copyright strike and they will notify the person that somebody has issued a copyright strike and we're going to mute you or remove your content. And then they are able to do back and forth and deal with that. With most of the platforms, it's the same. One of the things I tell creatives mostly is that whenever you're engaging with these platforms, you need to know their IP policies and copyright policies. Some of them are in fine print, little tiny provisions that you really need to be aware. There was a media station that had asked me to look at a certain site for them and what their policies say. And I was shocked to find that the policy said that once you put your content on our platform, you have given us exclusive right to reproduce, distribute, adapt, translate, communicate to the public, all these rights that you have given them an exclusive license to do that. And it went ahead to even say that you have even waived your moral rights, which in the law, the moral right cannot be waived. But this platform is saying you have even waived your moral right that whenever your image or whatever will be used, you can't complain. So the trick is usually just to find out which platform am I engaging, what am I putting there, what are their copyright policies? Because most of the time the platforms transcend borders. And so it may not be a platform owned by a person in your country, so you're not able to really regulate that. Okay, someone is asking about the 10% provision in the law. You're saying 10% may be equivalent to a chapter, then will I still be infringement? No, if your law says 10%, you calculate the 10% with the pages of the book, because how would I know the percentage? So if my book has, if I have a book that has 100 pages, I will be calculating 10% of 100 to get that 10% of what I'm allowed to copy. And if it is in your law, then you're okay. I see some information on the chat. Sorry, my moderator, I'm just going through the chat and seeing what to answer if I'm able, I'm able to. Yeah, I don't see any other question.
Okay. Just a quick one. I heard you mentioning that at the international level, it's actually 15%. So I wanted to check with you, when we enact a law, are we not deriving it from the international space?
When you make a law, you derive it from the international treaties that you have signed, but you're not, it doesn't expect you to say exact. Usually the international law provides a guideline and it says countries may make provision for 1, 2, 3, 4 in their law. But it doesn't say that you must say the same thing it says. So an international law may give you guidance and say countries may provide for an exception of up to 15%. So that means it could be 15 and below. So your domestic law could provide for 10%, that is still okay. Because the language usually in international treaties and conventions is that a member state may make provision in the law of an exception of up to 15%. So when it says that, it means you can do 15 and below. You could even do 2%.
Oh, okay. No, I understand.
Yeah.
More like the model law. I get it.
Yes, yes, exactly. And international law is usually just a model law, and you see, you can't apply it directly in your country. So you just need to fashion your domestic laws against this international law that you have signed.
Okay, no, thank you so much.
Again, remember, just a point to note, you are bound by an international instrument when you sign or ratify it. When you sign it or ratify it, you have given your intention to be bound by such provisions to be guided. But if you have not signed or ratified it, then you really don't have to. So again, another point of caution would be to check whether South Africa has ratified or signed the Berne Convention. I know Kenya has, South Africa may have, but I'm not very sure. So you would need to check, has South Africa ratified or signed the Berne Convention? And such information, you can find it on the WIPO website. The WIPO website, usually you will go to that instrument. They have the Berne Convention there. So when you go there, it shows you the countries that have signed or ratified and the dates they did sign or ratify.
Okay, no, thank you so much. Thank you so much. I see the comment saying, will this webinar be available? Yeah, it will be available on YouTube. You can follow Liasa on YouTube. It will be available there. For the copyright, I think it's public. I think it's public, the one for UNISA. I'm not sure about it, but I assume it's public. And what else? Okay. I think we managed to answer all the questions, and I'm actually happy, and I learned a lot from your presentation, Ms. Sharon, as well as Kolelwa, and it was so interesting. Honestly speaking, it was so interesting collaborating with the two of you. Thank you so much. And now we are moving into the closing part. Let me give Kolelwa an opportunity to give the closing remarks. Thank you.
Okay, I think it's Frida actually. Frida is the one that's doing the closing. Thank you very
My
much, though.
apologies. My apologies. Yeah, yes, Frida.
Afternoon, everybody. Can you hear me?
Yes, we can, Frida. You sound a bit far, but you can proceed.
I first of all want to thank the two emerging librarians for organizing this very informative session and getting hold of our very important Mrs. Sharon Water. It was a very well formulated presentation and very informative. I was in the beginning a little scared about how you are going to weigh the Kenyan law and make it applicable also to South Africa. But I was very surprised in the way you present it and put it forward and answer the questions. I think there are more questions in South Africa about copyright law and how and what will happen after the bill has been signed off and why the bill has not been signed off. For that, we invited the MD of Dalrou, and it was a pity that he couldn't join. But I would like us to move this session to a second session where we can have his input and we can compare what is happening and what was in the 1974 Act and what is now going to be stipulated in the new bill. Thank you very much, Ms. Sharon Water. I really appreciate it that you join us and give your time for us this morning. Now, you can understand after you have heard Kulelwa speaking, why she has been appointed as the emerging librarian of 2024-2025. Kulelwa, it was very interesting to hear how you are managing and giving advice to the people at the University of Free State. And I am again aware of the importance of the role that librarians play in this whole Copyright Act. Yes, we will move and have another session, and maybe if we can get Mr. Lazarus Serauba to deliver to us, we can ask also Mrs. Sharon Water to join us also for a short session so that she also has the insight of the new bill. Thank you very much, all of you, also Simon, for being the chair. Have a lovely day and a lovely weekend ahead of you. And I believe this is then the end of our session. Thank you again.
Thank you.
Thank you. Thank you. Bye.
Thank you. Bye bye, colleagues. See you next time. Please be on the lookout for our next webinars. Thank you so much for joining. Bye bye.
Thank you.